So here's a question. She has trial coming up. I think I might know who this person is. Let's say this case, usually trial happens like way after there have been other temporary orders and evidentiary hearings to make the temporary orders. Let's say the judge already has the psych eval report and there's other evidence. In the trial, does she have to present all that evidence that's already been presented to the judge and other for RFOs? Does she have to present all of it again in the trial, or can she just say, look, you've already looked at that evidence? Does that make sense?
That's a good question to ask the judge at the trial readiness conference, because some judges may allow that to come in. Some of them won't. Prior pleadings are generally not admissible in a trial, even if they're pleadings from this trial, except for cross-examination. But if you're trying to say, a year ago I testified to this in my declaration, technically that is hearsay. So you would just have to go over it all again. If it's not a trial and it's simply a long cause RFO, which kind of looks like and smells like a trial, then, the court can look at all these sworn declarations, even the ones from the past. But I would put it in your trial brief or your long cause RFO brief that those are the particular pleadings that you're going to refer to, so that the judge has an opportunity to review them before the issue comes up in the testimony.
Great idea. Yeah. And if you already had your TRC and you don't have another opportunity to ask the judge, what evidence do I need to present that's already been presented? I mean, you might want to just be safe, better to be safe than sorry, and just present. Let's say you guys had 6 other declarations that you've all filed in the past. Whatever ones you think are helpful, I would make copies of them and get ready to present them, even if they've already been presented, just in case. What do you think?
Right. I mean, she's not going to be able to bring in her own declaration to help her own side of the case. But if he gets up there and says, the light was green when I went through it, but his previous declaration says the light was red, well, you can cross-examine him with that declaration that shows a different statement, especially a different statement sworn under penalty of perjury, and that's pretty effective.
And same if there are grandparents involved. A lot of times there's grandparents who will write declarations, and you should be prepared for all of that.